please consider completing these 3 questions that we have for you. This information will help us determine what other topics that we can address for you in the future. And also remember that Certified Export Specialists and Certified Customs Specialists are eligible for 1 CES or CCS credit through the NEI for attending today's webinar. If you haven't logged your ID number at registration, please email it to us at infospot@roanokegroup.com. Before we get started, I'd like to tell you how you can interact with us today. Throughout the webinar, we encourage you to type your questions in the questions box in the control panel at the right of your screen. We'll answer as many questions as time allows during and at the end of the presentation. And now it is my pleasure to introduce today's presenter, Terry Cummings. I'm sure that those of you on the West Coast know Terry very well, as she has been a significant presence in your community for the last 35 years. For those of you who don't know Terry, she's Vice President for our San Francisco office. She's a licensed insurance broker, and her technical expertise is concentrated in cargo insurance, errors and emissions, property and casualty, and bonds for the international trade community. She's actively involved in numerous associations and has delivered countless presentations for them. Terry is a respected professional with a wealth of knowledge that she's always willing to share. With that, I'll turn it over now to my colleague, Terry Cummings.
To all the West Coast people, as I'm sitting on the West Coast, good morning, and to everyone else, good afternoon. Thanks for attending our webinar today. I have the privilege of looking over the list of registrants, and what struck me is the number of different companies and the sizes of the companies, the services that I know you provide are different. Some of you have one office, some of you have multiple offices, some of you have global offices. So there is a lot of difference between the companies that are actually attending this webinar. But there is one thing that you all share in common, and that is that you employ people. Even though there is the science of self-driving cars and everything by drone, we still can't get around in our industry of using actual human beings, and hopefully we never will. In today's presentation, I'm going to be telling you some stories. All of these stories are true. If you recognize any of those stories, don't be afraid. I'm not going to out you. But the reason that I'm sharing the story is because not only did the customer who experienced it learn something from it, but hopefully everybody else can learn something from it. I talk to many people about risk and exposures and how to protect themselves, and everyone wants to hear somebody else's story because they're just glad that it hasn't happened to them. So you're going to definitely hear some stories. And I have sometimes been accused of sounding a little bit too doomsday, so kind of the Chicken Little, the sky is falling, the sky is falling. And I'm here to say that I am not sitting here trying to tell you the sky is falling. What I'm here to say is the sky, or part of the sky, has fallen already. And part of that sky has fallen on some of your contemporaries in this industry, in logistics, customs brokers, freight forwarding, ocean transportation, air, all of these things, truck brokerage. The sky has fallen on many different companies, and it has been a painful lesson. So when talking about risk management, sometimes people think that we're only talking about insurance, and we're really not only talking about insurance, because you need to be able to also reduce your risk. You want to try to manage your risk. If possible, you want to avoid your risk. When appropriate, you want to transfer risk. And then, of course, you may want to insure your risk. But the problem is insurance doesn't cover everything, and it's not supposed to. And so some things you're going to have to also work to try to implement a good risk management policy. And hopefully by the end of this presentation, you'll have some more ideas of how to do that. So the balancing act, all of us have clients, right? And it is always important that your client remains satisfied with your service. So our objective is always to leave the customer happy. That's not always possible. So think about this. Something bad has happened. Your customer calls, your heart starts to race, you're trying to frantically think of a way to get your customer back on track and happy, but yet get off the phone as soon as you can. It's the person who's dealing with that customer, and it's their desire to make the customer happy. It's their desire to be helpful, that it's a good motivation, but it's potentially a dangerous motivation if taken too far, and many, many times it's taken too far. When trying to be helpful, there is a tendency to say too much, and that's less words is your friend in any type of liability situation. The less you say typically is the better, especially after the problem has already occurred. So your employees should really be thinking about, I need to not really get too involved in this conversation. I certainly can listen to what they have to say, and I can offer an empathetic reply. So saying something like, no, I'm sorry to hear this happened, and then tell them, you know, we're going to talk to my supervisor about it, and somebody will get back to you. That's an appropriate, professional, and empathetic reply. And at that point is when you get off the phone. There's also another temptation, especially if it's some basis in fact, where you might be tempted to throw somebody else under the bus, meaning that you're going to blame another party, a third party. That could be a government entity, that could be a carrier, that could be someone else. It's somebody else's fault. Be careful in doing that. Even if it's valid that that problem occurred from that origin, it doesn't help reduce the stress and the anger and frustration of your customer to talk about another party being responsible. Anger is still anger, whether it's directed at you or directed at somebody else. And it also keeps you involved in the process if you start to talk about other people's responsibility. Try to avoid using that as a method to try to manage your customers' emotions. Another thing, which is so basic that, you know, almost I don't want to insult your intelligence by saying it, but unfortunately it has to be said. Don't ever admit wrongdoing. Don't ever admit your liability. Don't ever say, it's my fault, it's our fault, oh my gosh, what have we done? You think that you probably imagine this could never be something that happens to you. You can't imagine anyone in your organization ever uttering those words. And unfortunately, you lack imagination if you can't imagine that, because it happens, and it happens frequently enough to be a real problem. It happened to a couple of years ago to one of our clients, and not only did they say it, but they wrote it. So that was much worse. Obviously, yeah, that was not good. But they wrote it, and it was there in black and white. It's a problem. When we talked about it to the customer, they said, and rightly so, we employ hundreds of people. How can we control one person's response? You might not be able to, but what you can do, and hopefully by the end of this presentation, what you will do is have some basis of training your employees, something that they can look at, some guidance you can give them, some do's and don'ts, some ways to respond that will keep that happening to you. Okay.
So Terry, just before you go on, I just want to be clear on what you were saying earlier. So you definitely want to address problems when they occur, but there's just a correct way and an incorrect way to do it. And a no response is a bad response as well, right?
Absolutely. I mean, we're going to talk about that. Thank you. Yeah, absolutely. Great. Yeah, it's not that you can't not answer the phone or you avoid email. you can simply respond by, you know, sorry this has happened, sorry to hear this has happened, talk to our supervisor, get back to you, and that's all that the first party responder should be doing. Okay, so let's talk about when you have a claim. So somebody's come to you, and we're going to talk right now about cargo, since it happens a lot of times with cargo, but it's not just cargo. But somebody comes to you and says, I have a claim, and they want to file a claim. So one of the biggest difficulties that logistics companies seem to have is directing your client to their own insurance company. They're really reluctant to try to tell them, you owned these goods, you have your own insurance policy, you didn't buy insurance from us, so really you need to file a claim with your own insurance. That is a very hard thing for a lot of companies to do, but it is the absolute necessity for them to do for a couple of reasons. One is they have an obligation in their own insurance policy to let them know immediately when something happens, so they can't just avoid or ignore that. Another thing is this is stuff that they own. It's not your things. You didn't insure it. You're not responsible. They're responsible. So that's a really a big problem, especially when you're talking about domestic logistics, transportation, because there's so much confusion about when is a carrier responsible, when is a forwarder responsible, what those insurance certificates actually say and what do they really mean and what the terms and conditions are. With international, it's a little less confusing because it's more consistent, it's more understood. Domestic is fraught with a misunderstanding, and even when you think to yourself, well, I'm not a domestic forwarder, a lot of you are truck brokers or property brokers. You're arranging interstate transportation and you're making money at it. So you are actually a truck broker, and that pulls you into the confusing world of domestic logistics. So if your client has insurance, you're telling them you need to file an insurance claim. If they have insurance and they want to file a claim against a responsible party like a carrier, like an NVO, then you can help them. You can file on their behalf. If you were the transportation party, such as an NVO, a motor carrier, a surface forwarder, an indirect air carrier, if you wore one of those transportation hats, then you might have a claim against you, in which case you would they would be filing a claim with their insurance and then filing a claim against you. The proper order of this, and this is again very difficult for people to wrap their heads around, is the cargo owner files a claim against their insurance company settles that claim with the cargo owner, and then they subrogate against the responsible parties. But so often the reverse is attempted. They want to get the money from the responsible party, and they hope to never have to go against their insurance company. And logistics companies sometimes enable them to try to do that because they're trying to be helpful. This is a very common problem, and it's something that people just need to wrap their heads about. The fact is, I don't own this stuff that was damaged, so therefore it makes no sense for me to be responsible for it. Another thing you want to avoid is the appearance that you are responsible. And so there is a temptation to be helpful. Let me help you arrange a survey. Let me send someone out there for you. Let me make a call for you. I'll come with you. The ocean carriers are doing a survey. I'll come with you and I'll be part of the survey too. The more you involve yourself in anything like this, the more it appears like you feel responsible. And so again, without trying to be unhelpful, you can be helpful, but you can be not as involved. If before you ever arrange or attend a survey for someone else, you would always need to get your insurance underwriter's approval before that it would even make sense for you to do something like that. It just gives the appearance that somehow you're part of this process. Now, what happens when it is your fault? There again is the temptation to say, oh my gosh, you know, we did do this, but this was our mistake. we're going to make this right. The thing is, there's two parts of liability. There's a part that says, in what situations are you responsible for it? All right, so in these situations, I know I'm responsible. That's the first part. Then the second part that says, if I was responsible, how much money are they entitled to have or to get from me for my liability, for my responsibility? So there's the monetary part. There's the scope of responsibility. There's the monetary liability. Those are the two parts. And this is true for carriers, for almost any type of logistics handling, warehousing, things like that. If you are responsible, then what is the limit of your liability? What have you communicated to the client that you are responsible in the amount of? Is it $50? Is that what your terms and conditions say? Is it 50 cents a pound? Is it $20 a kilo? Is it 19 SDRs? What is it? Because that is the extent of your monetary responsibility. So that's the hard part for people to get their heads around. If they are responsible, and I've heard people say, but we did it. It was our fault. We did do this. It was our forklift that tapped that rack, that collapsed all those racks and caused all this damage. We did it. And I said, I understand you did it, but if you hadn't done it, and if it wasn't your responsibility, they get nothing. If it is your responsibility, they get whatever specific monetary amount they're entitled to, but it is not full value unless you've agreed to that. And that's something that to keep in mind is you can be responsible, but you may not be responsible for the full value. In most cases, if you do an adequate job of limiting your liability, you wouldn't be. Now, segue into terms and conditions. Terms and conditions are vital in order to protect you, defend you, reduce your risk. And it's not just good enough to have some type of terms and conditions. They need to be adequate. So I'm going to give you an example. One of our clients had terms and conditions, but they weren't the industry standard. They were kind of a hodgepodge of things that were from transportation to some other types of services, and it was just a general terms and conditions of service. They didn't contain a lot of the language that is necessary and recommended by our industry. So they had a situation where they hired a trucker to move some product, just some freight. They were given instructions on how to load the freight. They attended the loading of the freight with the trucker and with the shipper. When the cargo was loaded and it was delivered damaged. The amount of damage was $800,000. The allegations are interesting. There's some number of allegations. One of them, which I'm not going to camp on, we'll talk a little bit later about, is the actual lawsuit mentioned the fact that they were quote unquote specialists, which is also something we're going to talk about how you sort of promote yourself. But anyway, the terms and conditions were not adequate to really defend them. In addition to this, the actual loading and origin of the shipment was out of Canada. So this company had different terms and conditions for Canada they did for the US, but again, neither one of them really addressed all of the things they needed to have in the terms and conditions. So the insurance company for the shipper paid the $800,000 and sued our client. The allegations in the suit talked about them hiring the trucker, them supervising the loading of the truck, that the trucker failed to load the cargo properly, and they failed to monitor it properly. Interestingly enough, the shipper's rep was also there. So they were also present and didn't do anything, didn't stop it, didn't say, oh, this wasn't done right. So anyway, they let the shipment go. At this point, it's still in negotiation, but it will be paid in some amount of money at the end of the day. all because the terms and conditions of service that they had really wasn't adequate to protect them. Another situation of where terms and conditions haven't worked, and these are terms and conditions that you would all have heard of, the National Custom Brokers and Freight Forwarders Association terms and conditions, which many of you use. So we had a situation where it was an importer who was importing machines from Japan. The custom broker had cleared about 145 shipments for the importer in the past, but the particular shipments, they had not had terms and conditions attached to it yet. So they hadn't issued any invoicing or anything, so that they didn't have the terms and conditions. Well, the cargo was going to be forwarded to a local consignee, and they were asked to arrange transportation. Called a truck broker. They gave the truck broker specifics about the size of the machines. They were oversized. The truck broker called the trucker, and off the machine went. It went down the freeway, it hit an overpass, it destroyed that machine. The next day, the second machine, there were two machines, picked up by the trucker, went down the freeway, hit an overpass, destroyed the second machine. The insurance company of the shipper paid $800,000. Then they sued the custom broker. The judge said, but when you were trying to use these national custom brokers and forwarders terms and conditions. You tried to use these, but you weren't acting as a customs broker when you were making this arrangement. You really were acting as a surface freight forwarder. As a surface freight forwarder, you have Carmack liability, and that's full value liability unless you choose to limit your liability, which you didn't. You issued a DO. Your DO has no mention of any type of limitation of liability. Of course, we know a DO is not a transportation document, but that the judge did reference it. And so therefore, you have no basis in mitigating your loss. And so the judgment was against that custom broker for $800,000. It went back on appeal, and the judge said, okay, we'll take into consideration you try to limit your liability. So with these terms and conditions, even though they're not really acceptable in this case, but we will say, okay, you tried. You'll pay $300,000. Truck broker, you limited your liability to $100,000 per conveyance. You'll pay $200,000. And carrier, you also have Carmack liability, which you didn't limit your liability by a bill of lading or a contract or tariff. So you're going to pay $300,000. So that's what's going to happen, and that is what has happened. So again, an example of even having terms and conditions. Again, depending on what you're really doing, do they really work in the services that you're providing?
So Terry, so the NCBFA terms and conditions are a good place to start, but like you're saying, they have to be crafted to incorporate your specific exposures, right?
Right. Yeah. So it wasn't that it really wasn't that there was anything per se wrong with the terms and conditions. It was the fact that as a surface freight forwarder, you have liability under Carmack. Under Carmack, it says you have full value liability unless you limit your liability by tariff, contract, or bill of lading. So because they were no longer called a customs broker, they were called a surface forwarder, that changed the story. So it wasn't that the terms and conditions failed, it was the fact that they were trying to use the wrong ones. And that brings up a really good point, Teresa, because if you offer multiple services, it's not that one terms and conditions fit all. I mean, if you're an NVOCC, you have a house ocean bill of lading. If you're an indirect air carrier, you have a house bill of lading. If you're a surface freight forwarding, you have a domestic bill of lading. So you're going to have multiple documents that spell out the scope of your responsibility. You just need to make sure that you have all of them for whatever services that you're performing. Okay, so contracts. We see in increasing amounts, shipping, logistics, transportation contracts. And not always, but in most cases, the one of the objectives of the contract is to transfer at least part of the risk to you. The issue with contracts are, and sometimes contracts are many pages. They could be one page. They can have many parts. They can have one part. There's no consistency to how the contracts will look and how they're written. I will tell you, one of the things that is a very common thing to do is when you're looking at a contract and you come to your insurance provider, you say, oh, here's the insurance requirements of this contract. Do we have all the insurance policies and the limits of insurance that they're requiring? Yes, okay, great, thank you, and go away. That's not the whole story. The insurance requirements are one part of the contract. The issues that we as insurance people, and of course you have to have a good transportation or customs attorney, also part of this process, because there's a whole legal review that has to take place. But from an insurance point of view, what we focus on is what are you agreeing to do? What is the scope of your responsibility under this contract? And does the insurance policies and the insurance requirements that are being asked, do they match? And you would think, especially when you're dealing with Fortune 100 and Fortune 500 companies, that they are going to be absolutely perfectly written, and they're not. They are not so many times. And it's because there's some basic confusion. So a few examples. A few years ago, I looked at a contract where the focus of the contract in the insurance side was under the general liability and umbrella liability. In fact, they wanted a $20 million umbrella policy as part of the contract. When I went back to the client, the actual shipper, I said, what is the reason that you need such a high limit of general liability and umbrella liability for the kinds of work that they're doing? It doesn't make any sense. What are you afraid of? They said, well, we just want to make sure that our product is protected while it's in their warehouse. And I said, well, under most general liability policies, it excludes care, custody, and control exposures. So you're not going to get money from the general liability or under the umbrella policy for this. You're going to have to look for another type of policy. So this is a common issue. Another common issue is they'll ask for all risk cargo insurance in the contract, but in reality, there's a force majeure clause. They're only limited to legal liability. They will ask for, we had a situation where in the contract they said they wanted a warehouse legal liability insurance policy. Yet the liability statement made them responsible for everything. There was no exclusion for force majeure. And it was a very, very, very large exposure. And the cost of that contract being insured was in the six figures. And understandably, our client did not want to purchase the coverage. Now, this went on for 3 months while they fought over it. We argued, they brought in people, I argued back, they brought in more people. So it literally went on for 3 months. They were doing this business for 3 months while they had no coverage. And at the end of the day, the last person they brought in was an attorney, and the attorney just said, no, it's right. You know, what they're agreeing to do is not going to be covered under this policy. So they ended up having to buy the coverage. Now, that's just an example of a Fortune 500 company who asked for a policy that didn't fit the liability. It is extremely important to look at all the parts of it. Another issue that is confusing and also misleading is if there's an insurance limit required on the insurance side of the policy, but there is no cap on your liability. So there's oftentimes a belief that that insurance limit is the maximum of your liability. And unless it says it's the cap or it's the maximum, it is not. It has to say that somewhere. There's also, even when there is a cap of liability, usually there'll be some type of statement that will say, in the event of willful negligence and or malicious intent and willful misconduct, there is no cap. The cap goes out the window. So it's really important to have qualified people to look at all of these parts before you sign anything. Now, for those of you in my, probably over 40, this is very funny. Okay, I'm expecting that all of you are sitting there laughing at this. For those of you who don't understand the joke, you're missing a very funny graphic. Anyway, you can't make assumptions about the people in your organization knowing what not to do or what to do. The story I just told, where it was a 3-month argument of a contract, said nobody wanted to believe, put them at more risk than they were, was actually signed by a vice president of the company without anybody's approval, without anybody's knowledge. I wish I could say this is the first and the second, the third and the fourth and the fifth time that I've ever seen this happen. There isn't, it isn't true to think that just because you have a junior or a less experienced employee, that those are the only people that are going to try to obligate you or do something that causes a problem. In many cases, it's not true. It is a senior person. It is a branch manager. It is an executive that is getting this and signing it, not thinking it's anything. We had a situation, I think earlier this year or last year, where client comes back and goes to me and says, oh my God, we have this judgment against us for a lawsuit that I have no record of us ever receiving. So he's frantically trying to figure out what's going on and why they have this judgment. We have our claims people looking at it. One of our people was able to get a copy of it from the court, and we found out that it was served 2 months, 3 months earlier to the resident agent, which was an employee in a different state. It was filed in a state that outside the corporate office, and it was signed. It was signed by a vice president of that company that he was served, had the summons. So digging into this a little bit further, we find that that vice president actually emailed the branch manager for which this situation had originated and said, oh, got this, and I served last night, I just want to tell you, we got served, what do we do? And the branch manager says, oh, well, yeah, we know, corporate knows about this claim, yeah, that's fine. Nothing happens. They didn't do anything with it. They didn't send it to anyone. They didn't tell the corporate office they had been served. Nobody found out anything until there was a judgment against them. So again, you'd think common sense would prevail, but it's not true. People in your organization may make some bad decisions and not think. They just not think things through. And it's just as important to educate your senior people as it is your less senior people. All right, well, sticking our head in the sand. One of my favorite things to do personally is avoidance, but can't really get away with that in a professional environment. So what does this really mean? This is something, when something happens, not necessarily even a claim. Maybe you find out that customer's not paying, maybe not paying their storage charges. Maybe you're aware of a problem that you think is going to escalate, and if I just kind of avoid it, if I just don't get back to them, if I just sort of don't tell anybody, maybe it'll just go away. It's not a good strategy for this. Helping it goes away, if you're fearful that contacting your insurance provider somehow puts a strike against you, they certainly can open up watch claims to say, you know what, this is not really a claim, we're not going to really work it as a claim, but we acknowledge the fact that this is the problem and this might turn into a claim. So the fact that you've made us aware of it is great. Gives us the opportunity if we do need to do something, because sometimes proactive involvement by attorneys can actually reduce the potential of a claim later on. And so it's not just cut and dry where you have a claim and you respond to a claim. There could be problems that come up that you say, I just need advice. I need to know what to do. What do you think we should do? Because we think this is headed in a very negative direction. So it's something that you don't want to put your head in the sand. One of the insurance companies we work with when talking about even demurrage costs, which is a ever frequent problem with shippers not paying their storage and consignees disappearing, is just the longer it sits there, the longer you don't hear from someone, the longer you don't get the check to pay, the more money you're accumulating, and putting your head in the sand and hoping it goes away is not a good strategy, because the longer it's there, the worse it's just going to get. So you don't want to make that choice to say, oh, let's just give them another couple of weeks. Let's just give them another couple of weeks. Let's give them another couple of weeks, because those weeks add up, and the amount of money will be at your doorstep. So written policies and procedures. So these are just asking yourself, in our corporate environment, do I have written procedures and policies that our employees understand how to deal with complaints or claims? And you just, you might, again, make the assumption, oh, they know what to do. They're smart people. They'll figure it out. They know I have an open door policy. I'm easy to talk to. But it goes beyond that. It's really important, because it's not just about customer complaints or customer complaints, claims. It can also be about vendors. It can be harassment. It can be discrimination. It can be all kinds of manners of things that happen. And if people are afraid to disclose this kind of information, it can blow up at a later time. You don't want to have a lawsuit against you because you haven't created a safe environment that is working with your employee to deal with problems. So it's important to make that a safe environment. The other point I was going to make is making sure that your employees also know that who the chain of command and communication is. One of the things that happened to one of our customers I thought was very interesting and unusual is they had significant losses in one of their offices, and they found out from an employee that came to them and said, the manager here has been embezzling money for quite a long time. And it was a lot of money. By the time it was all said and done, it was quite a lot of money. Should they have realized it through another channel? Yes. But the fact that this person came forward and told them something about their boss was pretty significant and amazing. But it was enabling that company to be able to put a stop to it. So that's another reason that you want to make your communication easy to your employees, so that they can also be helpful to you if they know something that you should know and they may be afraid to tell you. Okay.
Terry, so, with regards to that, I was wondering what you've seen some of your clients do successfully to help implement this type of culture into their environment. I'm sure there's numerous things, but if there's anything that you can think of that maybe stands out to you.
Well, I think simply part of it has to be with, it doesn't so much matter what we say, but how we say it and how we act. You know, you can certainly have this written policy that says, hey, we welcome all kinds of information. Don't be afraid to come to us. We're going to listen to anything you say. We're going to respect your confidentiality. Right. But if you don't practice that in your organization, and it is easy to see that people are judged and treated unfairly or maybe even discriminated against, then you're never, no matter how many written procedures and policies you have, it's not going to work. So you have to be able to represent that in a way you conduct yourself. I think that is the most important thing, is how do you conduct yourself, because the proof is really in that, not so much what you say or even what you tell the client. I mean, the employee. The employee is just going to look at, hey, how are they really acting? What's this relationship with this other person? If I go to them and complain, are they going to go to that person? You know, they have to be able to trust. Trust is
Right.
a big factor.
Right. Terry, we also have a question I wanted to go ahead and pose to you. And one of the attendees is asking, can somebody of a lower level, perhaps in the company, let's say a customer service rep that's not a manager or executive to speak, can they put us in a liability situation, or can we defend ourselves by saying that that person was not did not hold a position to agree to anything like that?
That's an excellent question. And I want to say, first of all, I'm not an attorney, so whatever I'm going to say, you have to take that into consideration significantly. But we've had this happen. So the argument was exactly as you say. It wasn't so much a junior person, but it was somebody that shouldn't have had the authority to obligate the company. This has happened on multiple occasions. And unfortunately, it doesn't really hold up because if that client took that signature and they had any kind of position of any kind of authority, whether or not technically they should have been able to do this or not, it didn't matter. But that's a very good question because we see that. And like I said before, contracts could just be a page. And so people think that, oh, this is nothing, I'll just sign it, and don't really read it or don't understand really what it says.
Right.
So.
Okay, thanks.
Okay, so avoid the temptation to overpromise. So we're all in a business where, you know, pressure is on your rates, your fees. It's a very competitive business. So you don't necessarily want to sell or can sell on rates. You have to sell on your service. You're having to sell on your relationship. You're having to sell on the things that you can offer that's not necessarily of a monetary relevance. So there goes the temptation to overpromise of what you're able to do. And I will just say that, as I said before, in that claim that I told you about, where in that lawsuit, it brought up the fact that they said they were a quote unquote specialist in this business, right? It was interesting that they included that in the lawsuit. But there's just some things that you want to avoid saying or putting on your website or putting in your emails or putting on your quotes, and that is these terms: safe, accurate, guarantee, on time, timely, expert. These are kinds of things that you want to be able to not be saying. You can certainly talk about your services without any kind of guarantee, and that's what you want to really stay away from. So another dependable, I would also stay away from. Insure, E-N-S-U-R-E is another one. Protected is something I would also stay, especially when you do, when you're the custodian of freight at all and you have responsibility to keep that cargo safe. You want to avoid the protective word.
And where are you talking about these, Terry, specifically in?
Well, I would say any kind of marketing material, but even more than that, just simple emails. Just simple emails or your quote form. I've seen people have a quote form where it has put some of these words in it, and you want to avoid because it could be seen as like some type of warranty, some type of guarantee. It definitely can work against you when you're promising these things, especially when you're talking about timeliness.
Right.
Well, you can look at any of these things and say, okay, I can think of how this could blow up in my face if I use any of these words. It can blow easily up in your face, and maybe you didn't even do anything wrong. So you want to just avoid when you can those kinds of statements.
Okay.
All right, so going from there into, we were talking before about avoiding, putting your head in the sand. I don't want to deal with it. I'm hoping it goes away. To, okay, I'm aware of this. It's a problem. It was a problem. but I am going to just fix the problem and never mention it to anyone. So we had a situation with one of our clients who was a customs broker, and they had been clearing shipments for one of their importers for many years and using certain classifications. Duty rates had been consistent all this time. One of the people from their employee left, and a new person came on board and started doing the entries and noticed that the classifications were incorrect for that importer. So they just decided to make the corrections and start using the correct classification, and lo and behold, that reduced their duty to CBP. Once the importer starts receiving the invoices, they notice their duty amount is reduced, and they're not doing anything different. Same cargo, everything's the same. So this gets to the president of the importer, who calls the president of the customs broker and says, what's this all about? Well, once they got investigating it, they found out they had been misclassifying it for 8 years. And this new employee comes in, realizes there's a mistake, fixes the mistake, but doesn't tell anybody about it. That's what I'm talking about, is you can find a mistake, fix it, but and I'm not suggesting that the person shouldn't have fixed it. The point was they needed to contact their management and let them know this had been happening, because the fix can then start a ripple effect. And the ripple effect is obviously a very unhappy client, not just because they've been overpaying for all of those years, but because they weren't even told that there was a problem, and it just was kind of under the radar. So that's something that is really important to let your employees know. Hey, do you find something that was wrong? Let us know, because maybe we need to communicate that to the client. If it's something significant, we need to get ahead of it so they don't find out about it in a way that's going to make them not trust us. Okay. Beware of setting precedents. This is important. I mean, all of these are important points, but this is something that happens frequently. And that is, when you have a situation where your client is unhappy, and the situation could be remedied by a little bit of money, $1,000, $1,500, $2,000. It's relative to the importance of that client to your business. It's a small amount of money. You don't really owe it, but you want to consider that customer's relationship and you want to make them happy, so you write a check. So this happened, and this has happened a number of times, but telling you one particular story happened to one of our clients, that they actually operated a warehouse and had a situation in their warehouse where the forklift, this is kind of the story I was alluding to earlier, forklift hit a rack. The racks toppled like dominoes. In fact, it was it kind of resembled, if you are old enough to know, the matchstick game where you threw all the matchsticks in a pile and then they all stuck up at angles. That's how this was. It was just a mess. There was also chemicals there, so there was a hazmat issue as well. So they had to bring a surveyor in. The surveyor then had to figure out even how to dismantle this mountain of mess. Goes through all of that, dismantles the mountain of mess. We have 8 different clients who have cargo that's caught up in this. And with each of those situations, we and our client offered the liability that they had under their terms and conditions in order to make restitution. They did this with each of the 8, except one of them wouldn't accept that. Now, interestingly enough, that particular client's cargo was only valued at $300,000. And because of the weight of their cargo, they were going to get $150,000 back from this liability payment from the insurance company. So that's a pretty good, 50% is very, very good. They also had their own insurance, so there wasn't the fact that they were uninsured. But they wouldn't accept the limited liability payment because they cited few years earlier, they had a claim. The client, our client, wrote them a check and never said anything about their terms and conditions. So they said, you can't change that. You've done it, and now we expect you to do it again. And it ended up the insurance company had to pay the full amount because they sued them. So the lesson to this story is, first of all, when you make a decision like this, it's not that you cannot make a business decision. It is you have to do it in a very specific way to not set a precedent, and as with insurance they call without prejudice. You are not setting a precedent when you pay someone. You're saying, I'm doing this as a commercial consideration. I am not saying that I'm going to do this any other time. I'm not saying that I even owe it to you. I'm doing this as a commercial consideration. So you definitely want to get a legal or an insurance assistance if you're going to pay someone money that you don't legally owe them, or you're going to offset. This also can be offsets. These could be credits you're giving back. It could be credits toward future charges. It doesn't have to be a monetary reimbursement to set a precedent. So this is something you want to be very, very careful about. Okay, I'm running out of time, so I'm going to go quickly. Fraud alert. This is something we're all very used to seeing in on the news and advertisements and emails and things like that. Is something fraudulent? I think the best piece of advice I can suggest is look for anomalies, something that's a little bit out of place, because something that's a little bit out of place or a little bit off, a little bit different, a little bit suspicious, they just mean that you have to ask a few more questions. Situation where one of our clients hired a trucker, and the trucker, before they hired the trucker, they said, you need to give us your insurance. So they faxed over their insurance certificate. So then once they got the insurance certificate, they came over and picked up their cargo and left. And then the customer wanted to know where the cargo was. Never arrived because they weren't the real trucker. Just because they had their hands on an insurance certificate didn't mean anything. And nobody ever stopped to ask them any questions. That's something that, unfortunately, in our day and age, if something seems a little bit off, you need to ask a few questions. You may need to look at a little bit more information. Another danger is when you have just an internet relationship. Somebody comes to you and says, we want you to handle this for us. We want you to ship this for us. This can create all kinds of problems on the other end with payments being paid or demurrage charges. This is a situation where even an agent, a Chinese freight forwarder, contacted a UK forwarder and had shipped containers over to the UK. The forwarder handled it all for them. It was at the carrier's warehouse. They kept waiting for the original bills of lading. They kept waiting and contacting the Chinese forwarder and saying, we can't release this cargo without the original bill of lading. Meanwhile, demurrage is accumulating, and we really need your response. Well, come to find out, they said, we will send you the original bills of lading if you wire transfer us $50,000, because they were holding it hijacked. So moral of this story is be careful about things that seem a little bit too good to be true, things that seem a little bit off, people that contact you for business without any kind of referrals or any kind of knowing how they even got you. Check things out. Don't just make assumptions. This is important because significant changes in instructions really can be a red flag, and it's a big red flag. It's something that you definitely want to ask or dig a little bit deeper. We've had one of our clients, or multiple people in fact, wire transfer money to people that they thought it was their agent they owed money to. It came from an email, but it looked exactly like their client. It had the person's name. Everything looked okay from first glance, but in actuality, once they realized after they wired it to a fraudulent party, they went back and looked at the email. There was some things that were not absolutely accurate. Didn't think to even think about that. There's a story of an importer who was importing, I think he was importing ball bearings, and they had their supplier was the same supplier they'd been using. They had been given instructions to pay a different party than normal, but they have the instructions from this German supplier, so they didn't think anything about it. And then lo and behold, they wire transferred the money, and it was not to their supplier. Come to find out, it wasn't the importer's website that was hacked. It wasn't the supplier's website it was hacked. It was a broker out of Italy whose website was hacked that had the connections and that information that created the false email and embezzled or fraudulently deceived them of all of that money. So it's very important to, when you have significant instructions, significantly different instructions than you're normally used to getting, that you use a third-party resource to contact them and say, I have an email from you that says this and this. I want to make sure that this is from you. Don't use the contact details from the email. Go and find a third-party source and contact the people and ask them if that was from you. One of the things, insurance-wise, there's a coverage called social engineering, and it's typically part of a crime policy, because usually crime policies won't pay for, will pay for theft, but when you have deliberately, intentionally sent money, nobody has really stolen from you. Even though they've defrauded you, you have sent it willingly. And so that's a really important thing to check on your policies if you have the social engineering insurance coverage. All right, something fishy about the carrier. I've kind of already dealt with this. If you've got some questions, look at IDs, take pictures of IDs, look at that truck, make sure that all of these things seem permanent on it. It's not something that's just been, you know, put on there at the last minute. You just ask some questions, but definitely checking IDs, checking paperwork, or even making a phone call to the trucking company and say, do you have a truck that's supposed to be here? Asking, making sure, especially if somebody shows up and that you weren't expecting. And then lastly, trust is great. You trust your employees. These people you have great relationships. You wouldn't employ them if you didn't trust them. But it's not enough. It's not enough to just trust the people that you employ. Sometimes they make bad decisions. Sometimes they have bad intentions. And so it's really important not to just assume that they're all going to take care of everything. You need to be looking at, am I doing, you know, are they taking vacation at least 5 weeks, 5 days at a time? Are they changing their passwords routinely on their computers? Are they removing any kind of laptops or devices out of my office? Do they have a company credit card? Do I have a limit, a max limit on that credit card, or can they just spend whatever they want, which has happened to one of our clients, spent whatever they wanted and then left the company, and then all of a sudden the company was stuck with that. So it is important to also just have a good review yourself of your own employees and just making sure that they're doing the best for your company. So it's a lot of information. I know it's a little bit overwhelming, but don't be overwhelmed, be motivated, because you can only do the best you can. And if you think about this, if you learn some things today that you can take and move forward with, that just puts you in a better situation than you were yesterday. And if you can just be a bit more protective and a little more educated, then that is going to be to your benefit. Thank you.
Okay, Terry, let's go on to the next. So before, I really want to thank you for a thought-provoking and informative presentation. And I also wanted to remind everyone that the recording of today's webinar and the slides will come to you within a couple of days. And if you had any questions, we'll just take questions for just a couple of minutes because we are running over, but we do appreciate your participation. So, but if you do have some questions, now's the time to go ahead and enter them into the GoToWebinar viewer in the questions box there. And also, we ask that you complete the survey that's going to launch at the end of the presentation. Also want to remind you two things. We have our two webinars coming up for the remainder of the year, one in September, September 20th, Think Like a Criminal, and also on November 9th, Shipper Contracts and Master Service Agreements, the devil's in the detail. So that is probably in line with some of the things that Terry was sharing with us. I do think, Terry, you wanted to just briefly mention this piece that's on the screen right now.
So you're going to be getting a copy of this presentation along with this guide about identifying red flags. So some of what I talked about today, some of those red flags will be addressed here, as well as how to respond to the red flags. This is to use with your employees. It's something that you can use as a training tool with your employees. You can ask them to sign it. You can ask them to review it. You could do it individually or together. One of the things to keep in mind is it's not just enough to do things one time. It's repetitive information. It's reminding people about these kinds of things that help keep it in the forefront of their mind. So it's a place to start.
Okay, Terry, I have a couple of questions here, and one of them is, our employees have titles like claims specialist. Would that fall in a dangerous area? I guess, you know, when you were mentioning overpromising and.
Yeah, that's a good question. Again, a little bit of a legal question. I would think no, because I don't think the two together is really something that I could really see as sort of using against you. It's possible, I suppose, but it's not certainly part of what I was referring to.
Okay. And we have another question. Do the NCBFAA terms and conditions cover activities as a property broker?
Well, very good question, and I want to also be careful of how I respond. So not necessarily. That's kind of a legal question, but let me just say this: that property brokers don't have cargo liability. Okay, so they're not going to have a bill of lading or anything like that is going to be like a forwarder would have or a carrier would have. You probably should have your own agreement as a property broker. We certainly see a lot of broker carrier and broker shipper agreements, but it's usually property brokers don't rely on the NCBFAA terms and conditions, but I suppose it's possible that they could, because they're not really they don't have a transportation authority like the other authorities have.
Right. Here's a question about terms and conditions. Do we offer terms and conditions for forwarders or brokers as Roanoke?
No, but what we do have is something called, something called risk review, which gives you 3 options of attorneys that we have arranged services through that can actually either provide you terms and conditions if you don't have them, can review the terms and conditions you have, make suggestions depending on, for all modes of service and all types of operations. So you can certainly contact us for that information. There's a multiple options in that regard that you can avail yourself of.
Okay. Okay, well, I want to go ahead and wrap it up now, as we did go over. If we didn't get to your questions, we will try to get an answer out to you as soon as possible. Again, thank you everyone for joining us today. Look for the emails from us with the information we mentioned before. Have a wonderful day, and this concludes today's webinar.